we'll start with a brief overview of what has been termed crimigation. And the definition really is the intersection of criminal law and procedure and immigration law and procedure. So it sounds kind of simple, but it's the combining of two distinct bodies of law. And for most of America's history, these actually operated almost entirely free of one another. And what I'll do first is go over some brief historical background on how we got to where we are present day. There are some significant legislative actions that were taken years ago that, again, led us to the moment where we're at. One of those is the Page Act of 1875. And that kind of marks what many legal scholars think of as the beginning of the federal government's regulation of immigration. And what that did was prohibit entry into the United States of convicted felons. Now, not long after that, Congress then introduced a provision. So at first, right, we're just talking about convictions based on felony charges. Then, again, they add to that and have still to this day, it's crimes involving moral turpitude. And that is, we'll discuss later, a lot of controversy and concern because it's not clearly defined. And then we're brought to 1922, and they added on to the themes of crimes involving moral turpitude, convicted felons. And then they decided, okay, we're going to exclude and deem worthy of deportation those that are convicted of crimes involving narcotic offenses. And so that's kind of the historical basis, again, to where we are today. Some of the issues that I want to highlight that, because it's all very serious, and part of that lies in the fact that despite these two separate bodies of law coming together, and us calling it crimigation, they were two distinct bodies, again, at one point in time. And immigration law is deemed civil. So what that means is that most constitutional procedures for that you think of in the criminal context do not apply. So when you are in immigration court proceedings, there is no Fifth Amendment privilege against self-incrimination. There is no Sixth Amendment right to counsel. And there's very, very limited Fourth Amendment prohibition against unreasonable search and seizures. So, of course, that causes concerns for, I'm sure, a lot of immigrants, a lot of people who care about immigrants, and a lot of attorneys. Furthermore, so I have on the screen some statistics. And so what's happened over the years is that the number of people removed due to having committed a crime has grown because the number of crimes that can result in immigration problems has expanded dramatically. Similarly, the number of people in immigration detention has multiplied because Congress has boosted immigration officials' legal power to detain and provide them with the money to do so. And at the same time, the number of people prosecuted for immigration-related crimes has increased because the criminal justice system has become a central feature in the way some states and federal governments seek to control immigration. Each of these trends has developed over a series of legislative or policy amendments, and all are significant to the creation of crimigation law. And if you can see, these are some statistics that reflect the trends that I've just discussed, right? So what's happening here is arrests for immigration crimes doubled from 1994 to 1998. That means, and when I say immigration crimes, I mean things like entering the country illegally. So that's doubled again from 1998 to 2004, and yet again from 2004 to 2008. Arrests for immigration crimes actually grew faster than any type of federal crime from 2006 to 2010. And just about all of the increase in federal arrests, that's about 95% from 1998 to 2018. So that's a pretty big period in time, can be attributed to immigration crime cases. Furthermore, immigration prosecutors and convictions now make up one of the two most frequently pursued types of crime in the federal court system, competing with drug offenses for the top spot. So federally, it's immigration crimes and drug crimes. And that's, again, we're talking about serious issues here. So here I'm discussing the legal framework and some terms that I'll be going over. It's a lot to take in. So I've tried to make it as simple as possible, but some words you'll be here I'm trying to define up front so that you have a better idea of what we're talking about. So we'll be talking about inadmissibility, and that's people seeking to be admitted to the U.S., and they're going to be subject then to being inadmissible. And deportability, that's probably one folks have heard of, right? And those are people who have been admitted already, and then they're subject to the grounds of deportability. Removal is kind of a newer word. It replaces deportation proceedings, so it involves both deporting and inadmissibility. Conviction, that's going to be defined later. It's specific and much broader than traditional criminal law and procedure. Then I mentioned this earlier, crimes involving moral turpitude. There's no statutory definition. So I was able to do research, and it has been defined as conduct that shocks the public conscience as being inherently base, vile, or depraved, contrary to the rules of morality and the duties owed between man and man, either one's fellow man or society in general. And that can be and has been used very broadly. Aggravated felony. This is a really important term. It has the most damaging immigration consequences for a non-citizen. I'll go over that again later, but it's very serious, the crimes in that category. And then controlled substance offenses. And that's any crime involving the possession, sale, and transport of illegal drugs or drug paraphernalia. So why are we here, right? Because the impact of what's happening, of what we've been discussing on immigrant communities. And there are major consequences for criminal convictions based on immigration status. So we have removal or deportation from the United States. And these are potential, right? Like it's going to be case specific. We're talking about big overarching consequences. So removal from the United States, ineligible for an immigration bond resulting in mandatory custody during removal proceedings, ineligible for immigration waivers or relief, and ineligible for citizenship. So those are very serious consequences, and those are all things that can happen based on sometimes not even a full conviction. Conviction. What does that mean? So it is, again, I'm saying the same thing over here over and over again. Hopefully it sets in because it's a lot of information. But what is conviction as defined for immigration purposes? So a formal judgment of guilt of the non-citizen entered by a court, or if adjudication of guilt has been withheld, where a judge or jury has found the non-citizen guilty, or the non-citizen has entered a plea of guilty or nolo contendere, meaning no contest. So if you plead no contest, that could result in immigration consequences, or has admitted sufficient facts to warrant a finding of guilty. And the judge has ordered some form of punishment, penalty, or restraint on the non-citizen's liberty to be imposed. Thus, so what does that mean? What are some practical examples? A court-ordered drug treatment or domestic violence counseling alternative to incarceration is a conviction for immigration purposes if a guilty plea is taken, even if the guilty plea is or might be later vacated. Sometimes that's called a suspended sentence. A deferred adjudication without a guilty plea is not a conviction. And just a note, a youthful offender adjudication is not a conviction if similar to a federal juvenile delinquency adjudication. So, as you see here, it can be convoluted, messy. And that's one of the reasons why we're here, to go over what that means and the implications of what this means. So now that we have hopefully a better understanding of what conviction means, let's go over once or whether there's a conviction, what are the bases for what may happen, right? So earlier we said we were talking about inadmissibility. So how could you be inadmissible? So criminal inadmissibility grounds, if I can say it. So what that means is it will or may prevent a non-citizen from being able to obtain lawful admission status in the United States. May also prevent a non-citizen who already has lawful admission status from being able to return to the U.S. from a future trip abroad. So that includes a lawful permanent resident. If you leave and come back, you could be affected. So a conviction or admission, and what I'm going to go over is kind of the themes of the types of crimes, because they are most serious, that we were discussing earlier. So that's the controlled substance offenses, crimes involving moral turpitude, and then a few other that are more common. So conviction or admission of a controlled substance offense. And the Department of Homeland Security doesn't have to have the same standard. So if they just have reason to believe that the individual is a drug trafficker, which is a much lower threshold than other things, then this could be grounds for being inadmissible. Conviction or admission of a crime involving moral turpitude. Again, crime involving moral turpitude. Oh my goodness. And again, I hope you're picking up here. This is conviction or admission. So that doesn't mean if you're just admitting to the facts of the crime, that could be grounds for inadmissibility. So when we say crimes involving moral turpitude, we're thinking offenses with intent to steal or defraud as an element. So each crime will kind of have laid out things that require, that kind of define it, right? So an example of an offense with intent to steal or defraud as an element would be, think theft or forgery. Offenses in which bodily harm is caused or threatened by an intentional act, or serious bodily harm is caused or threatened by a reckless act. So there we think murder, rape, sometimes some manslaughter, and assault offenses as well, which are obviously not as serious, but Again, we've seen this being used pretty broadly. Most sex offenses, now they do have, excuse me, I'm sick, but they couldn't keep me away. I really wanted to be here. So I've got a cough drop in and I may be coughing a little bit. We do have the petty offense. So what that means is if you've been convicted of a crime involving moral turpitude, okay, just one, and you have no other one in that category, and the category is crime involving moral turpitude, and the offense is not punished for more than 1 year and does not involve a prison sentence that's more than 6 months. So that's an exception, meaning you would not be, there would not be grounds for you being inadmissible. Another crime that would be in this category would be prostitution and other unlawful commercialized vice. The last one we've got here is conviction of 2 or more offenses of any type plus aggregate prison sentence of 5 years. So that just means in total, if you got 2 or more crimes, any kind, it doesn't have to be on the list or what we've talked about, then that could, not necessarily will, but could be grounds for inadmissibility. Okay, the one I can't say for some reason, even though it's most common. I'm going to blame it on the cold. Deportability grounds. So this is, again, I think folks have probably heard a lot more about this. And so this will or may result in deportation of a non-citizen who already has lawful admission status, so such as a lawful permanent resident, green card holder, or a refugee. So what does this mean? This has a higher bar. So if you go back and think about when we were talking about inadmissibility, that could be a conviction or admission. Here, I want to say most of the time, because there are always exceptions, this requires a conviction. And again, we've defined that, so still, it's pretty broad. Conviction of a controlled substance offense. Then one exception here is where you wouldn't be grounds for removal here is if you have a single offense of simple possession of 30 grams or less of marijuana. Okay, that's the only exception under the controlled substance offense. Oh my goodness, crime involving moral turpitude again. So grounds for deportability, one CIMT or crime involving moral turpitude committed within 5 years of admission into the U.S., and for which a prison sentence of 1 year or longer may be imposed. 2 crimes involving moral turpitude committed at any time after admission and not arising out of a single scheme. Another one here is conviction of a firearm or deconstructive device offense, conviction of a crime of domestic violence, crime against children, stalking, or a violation of a protection order, criminal or civil. And I've seen this come up a bit. So yeah, so it's the violation of the protection order. And I've seen, even if you're just admitting to the facts of the protective order, all of these things in that arena can be grounds for being deported. And conviction of an aggravated felony. I mentioned earlier, aggravated felonies are very serious. They leave the least form of relief amount of defenses. And so if you're convicted of an aggravated felony, in addition to being deported, you're not going to have most waivers for removal. You're going to be permanently inadmissible after you're removed. And there's a possibility for an enhanced prison sentence for illegal reentry. So it is very, very serious. And not many ways to get folks out of that kind of situation, unfortunately. Excuse me. And the list goes on. And this, again, we started out, folks, with this has been an expansion of crimes that will cause immigration consequences. And I think going over these slides kind of point that out, right? So we're going conviction of an aggravated felony. So these crimes included, we're talking about specifically aggravated felonies. That include, and this is kind of, you may think of this, right? Murder, rape, sexual abuse of a minor, drug trafficking, firearm trafficking, crime of violence, with a prison sentence more than 1 year, theft or burglary, prison sentence more than 1 year, fraud or tax evasion, but the loss to the victims has to be more than $10,000. Prostitution business offenses, commercial bribery, counterfeiting or forgery, again, prison sentence more than 1 year, obstruction of justice or perjury, prison sentence more than 1 year, and various federal offenses. So some examples are money laundering, certain firearm offenses, explosive material offenses, alien smuggling, and similar state offenses. And there's more. Also, attempt or conspiracy to commit any of the above. So this isn't even everything. And just a note on the at least 1 year prison sentence or more, that includes a suspended prison sentence of 1 year or more. So again, kind of expansive, broad interpretations for how the grounds for how you could be deported or one could be deported. So criminal bars on a lawful permanent resident cancellation of removal. So that's a type of defense based on the status of 5 years or more and continuous residence in the U.S. for 7 years after admissions. That's, again, the aggravated felony. Also, offenses triggering removability refer to in the inadmissibility grounds if committed before 7 years continuous residence in the U.S. Now, if you're not a U.S. citizen yet, but you do have you are a lawful permanent resident, what are bars on getting your citizenship? Conviction or omission of the following crimes. What that would do would mean that they would find that you would not have good moral character for up to 5 years, and thus you would not be able to get citizenship. So controlled substance offenses. Again, though, we had that exception earlier. I talked about simple possession of marijuana, 30 grams or less, crime involving moral turpitude, unless it's a single offense, not punishable for more than 1 year in jail with a prison sentence 6 months or less. That would be an exception. 2 or more offenses of any type and a total prison sentence of 5 years. 2 gambling offenses or confinement to jail for a total period of 180 days. Also, conviction of an aggravated felony on or after November 29th, 1990, and conviction of murder at any time permanently bars the finding of moral character required for citizenship. So things you would want to consider. Final thoughts. We went over a lot of really heavy stuff. And so I just wanted to note here at the end and kind of ground us with why we're here. Changes to immigration law have drastically raised the stakes to a non-citizen's criminal conviction. So that's even lawful permanent residence, right? And as a matter of federal law, deportation is an integral part of the penalty that may be imposed on non-citizens defendants who plead guilty to specified crimes that I tried to go over and make clear. But again, I understand it's a lot to take in. And one tool we do have in our toolbox that you will want to keep in mind is effective assistance of counsel, which is a constitutional requirement. That means if you're a defendant and you may face immigration consequences, you're entitled constitutionally to be advised of those consequences. So please consult an attorney. Know that that's something that you have. And if you are meeting with an attorney, you should be advised of potential immigration consequences.